The committee will come to order. The Oversight Committee exists to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is the mission of the Oversight and Government Reform Committee. Today, a debate is unfolding in America that comes down to two fundamental questions about how much government do we need in our lives. From this side of Capitol Hill all the way to Pennsylvania Avenue, there are hearings every day and listening sessions every day about the creation of jobs. Today, we are going to listen about whether or not a tsunami of regulations, some well-intended, some expedited, some perhaps in conflict with each other, are creating an environment in which the economic downturn will be prolonged. On one hand, the Obama administration has been stubborn in its determination to issue costly regulations and paid little regard to the impact that these mandates will have on the broader economy. On the other hand, the administration has admitted that there are at least 500 regulations that need to be withdrawn. They have talked in terms of duplicate regulations. They have talked in terms of relieving regulatory burdens on job creators, so much so that the Gallup poll of job creators, of entrepreneurs, considers the #1 impediment to job creation to be, in fact, regulatory excess. Today, we are going to hear about utility MACT, the Environmental Protection Agency, EPA's proposed issue of this rule, which is clearly by its own terms an $11 billion rule, but in fact, by most of the people on both sides of the aisle who are looking at the high end of what it could cost being 10 times that or more. Anything which causes the price of energy and its availability to suddenly change will disrupt markets, will change the balance of cost effectiveness here in America. Because after all, if you increase the price of an essential fuel like electricity, you will by definition increase the cost of doing business, and particularly for manufacturing jobs which often depend on high volume of electricity in order to create efficiencies to offset advantages third world countries have in less expensive labor. Whether you are in Florida or, as our first witness today, Virginia, whether you are a donor of the fuel of greatest choice, that being coal, or in fact you are a recipient of that to power your power plants, you know that in fact the grid depends at least 51% on reliable power that today comes from coal. We applaud the EPA for continuing a tradition to try to find ways to continually clean up all of our energy sources, to reduce particulates, and particularly to set a standard for reducing mercury. We have no objections to the attempt to, on an ongoing basis, increase the reliability of our power plants to deliver clean energy. At the same time, 24 Attorneys Generals, both Democrats and Republicans, have requested the EPA to postpone issuance of its rule for 1 year. Today, we will hear from one of those Attorney Generals along with the EPA and a think tank individual, giving 3 different views from 3 different perspectives. This is not the last hearing we will have on the speed with which we can make air and water cleaner and the cost that it will have. In no case do we want anyone to misunderstand. If this rule does not take place, air and water will be as clean tomorrow as it is today. If this rule takes place a year from now and it is different and better it will only increase the cleanliness and the reliability that comes with good, clean energy here in America. The goal today is to hear, is this the right time? Is this the right speed? Is the science ready? And most importantly, what will be the impact to the various states? And with that, I'd like to recognize the ranking member for his opening statement.
Mr. Chairman, I yield to the gentleman from Virginia, Mr. Cuccinelli.
I thank the ranking member. It's a shame that the committee majority shows so little interest in legislation that might promote technological innovation and improve management of federal information technology. Instead, we are conducting another partisan hearing that isn't really related to our committee's primary jurisdiction. Now the committee is holding a hearing to attack common sense EPA limits on mercury, arsenic, dioxin, and other pollution. Consider the pressing technology-related topics in which this committee has not held a hearing: cloud computing, data center consolidation, an update to FSMA, implementation of the Chief Information Officer's 25-point plan, or improvements to the acquisition workforce. We have not held hearings on filling the gaping holes in our acquisition workforce or about how to improve training for acquisition personnel. We have held markups of the legislation to create new unfunded mandates and private sector regulations, the DATA Act, but not on legislation to streamline or expedite data center consolidation or the shift to cloud-based data storage and processing. Under Republican leadership, this committee has abandoned the most important issues in federal technology and management issues, which are of vital importance to one of the most important job-creating sectors of our economy, technology. Instead of focusing on these important topics, the committee majority has decided to attack limits on mercury and other toxic pollution. The EPA is updating standards to regulate toxic mercury pollution because the courts found that a prior rule issued under the Bush administration on behalf of the polluters violated law. Under the Obama administration, the EPA actually is trying to do its job and reduce toxic pollution as Congress directed in 1990. As the EPA attempts to administer the Clean Air Act, it is worth recalling that the Clean Air Act used to have bipartisan support. It was signed into law by a Republican president 40 years ago and strengthened substantially by a Republican president in 1990. By any empirical measure, the Clean Air Act is a wild success. It saves 160,000 lives annually by preventing deaths that would otherwise be caused by air pollution. Major regulations implemented in the Clean Air Act have saved far more money than they have cost to be implemented. Since the Clean Air Act was passed, the U.S. economy has grown by 200%, and we have fostered a vibrant new clean energy industry that creates jobs without creating diseases associated with fossil fuel production. The regulation this committee majority is attacking today is typical of the Clean Air Act regulations that will save lives and money. According to CRS, the utility MACT rule would save 6,800 to 17,000 lives per year, with a net savings of at least $48 billion. The Republican claim to be concerned that this life-saving public health standard will threaten the reliability of electricity supply. Once again, we are presented with a false choice. In this case, a false choice between electricity and clean air. Those of us who have been outside today breathe cleaner air right here in the nation's capital as a direct result of the Clean Air Act. And yes, there are far more cars on the road and kilowatts of electricity being produced than when Congress passed the Clean Air Act in 1970. The primary Republican witness today, Virginia Attorney General Ken Cuccinelli, he has used his office to focus on narrow ideological issues that, in my view, squander taxpayer investment. He subpoenaed, for example, former UVA professor Michael Mann in 2010 because he believed that Mann's well-regarded climate research might qualify as fraud under Virginia law. Not surprisingly, a circuit court disagreed. Now Attorney General Cuccinelli is appealing to the Virginia Supreme Court. The witch hunt has drawn condemnation from 800 Virginia scientists, the conservative Richmond Times-Dispatch, and almost every other major newspaper in the Commonwealth, the American Association of the Advancement of Science, and so many others. It is appalling that taxpayer money would be squandered in a vain attempt to discredit a single climate scientist. In addition to litigating against his own state's premier university, founded by Thomas Jefferson, he filed a lawsuit against the federal government for the EPA's finding that greenhouse gas pollution poses a danger to human health and welfare. Unfortunately, as a caricature for the modern Republican Party, Attorney General Cuccinelli has fulfilled the predictions of the Washington Post editorial board, suggesting that given his bizarre ideas, he would very likely become an embarrassment to the Commonwealth. I regret that we are holding this hearing instead of going into other topics that I think would be more productive and would, in fact, create jobs. With that, I yield back.
I thank the gentleman. Members will have 7 days to submit opening statements and extraneous material for the record. We will now recognize our first witness, the distinguished Attorney General of the Commonwealth of Virginia, the Honorable Ken Cuccinelli. Pursuant to the committee rules, all witnesses here will be sworn. Would you please rise to take the oath? Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record indicate the witness answered in the affirmative. I'm going to take a point of privilege very briefly. I appreciate your being here today. I'm going to regret that there were some levels of the previous opening statement that may have seemed personal, and I apologize to the extent that you were offended. We appreciate your being here. We recognize you're one of many Attorney Generals that is involved in this, and I think on an overall committee basis, I would say that we're very pleased to have you here as a representative and hope that you'll take the spirit of the full committee without any questions that you may have from other opening statements. And with that, you're recognized. Yeah, you have to push the little green button first, and then you may have to get a little closer. Thank you.
Chairman Issa, Ranking Member Cummings, members of the committee, I'm Ken Cuccinelli, Attorney General for the Commonwealth of Virginia, and I want to thank you for the invitation to speak about the MACT rule today. One of my duties as Attorney General, as is common among Attorneys General, is to serve as the attorney for utility customers in my State, advocating for fair rates for customers when electric utilities seek rate increases from the Commission that approves them. As you know, public utilities that have their rates set by State commissions are entitled under the U.S. Constitution to recover from customers the necessary expenses they incur to provide utilities. That includes the expenses to comply with Federal laws and regulations. That means every time new environmental regulations are placed on electric utilities, it's actually the customers that I represent who pay the cost. This isn't to say that environmental regulations should automatically be rejected because they impose some costs, but it does mean the EPA should follow the proper procedures to ensure the alleged benefits of the regulation outweigh the real-world costs. And unfortunately, the EPA hasn't been following normal procedures. In its regulatory impact analysis for the MACT rule, the EPA conceded that the rule would increase electricity prices and would cost jobs in certain sectors. Yet the EPA admitted that it did not have sufficient information to quantify those losses. In fact, the rule will have a huge economic impact on this nation. First, it will increase electricity prices over the course of the next 5 to 10 years of between 10 and 35%. That will vary depending on where you are and what the conditions, particularly of your generation and transmission, are in your region. And that can be a financial death blow for businesses struggling to meet payroll and families on fixed incomes. Second, retrofitting power plants to meet the standards will, as you all know, be prohibitively expensive. So there is no question that certain plants will close and the nation's electricity supply will decrease, leading to upward pressure on prices and likely brownouts and possibly blackouts in strained periods of use. The EPA even concedes that at least 10 gigawatts of electricity will be lost from the nation's power grid. Of course, FERC's initial analysis says over 80. That's a pretty dramatic difference between the EPA and the people who you would expect to know better. Third, while the EPA says it can't quantify the number, it acknowledges that jobs will be lost. There are estimates of 180,000 jobs per year between 2013 and 2020. For Virginia, the situation is even bleaker than for the rest of the nation, though not Mr. Connolly's part of Virginia, which is where I live. A majority of the electricity for Southside and Southwest Virginia is generated from coal. Since the MACT rule will significantly increase prices for electricity produced from coal, the poorest part of my state will face the largest price increases, including part of Appalachia, one of the poorest parts of America. But it gets even worse. The most important industry in Southwest Virginia is coal mining. These regulations make coal more expensive and less desirable to use, which means the economy of Southwest Virginia, again, including Appalachia, will be devastated by the destruction of the coal industry and the jobs lost along with it. Now, whatever you think of the benefits of the MACT rule, a decision about whether it's prudent policy simply can't be made without considering these other impacts, and not just for Virginia, but for the entire country. What's even worse is that for regulation this important, the EPA set just 104 days, recently extended to 134, to review the more than 960,000 public comments on the impact of the rule. If you compare this to other significant rules where the EPA set review periods of more than a year with less comments, this abbreviated review period occurred because groups that support the EPA's position sued the EPA, and then in a very friendly settlement, the EPA agreed to the short review period. This kind of gaming of the system is an affront to proper procedure and the rule of law, and it really should concern people across the spectrum. This obvious attempt to rush the rule through was so outrageous that, as you noted, Mr. Chairman, I, along with 23 other Republican and Democrat States Attorney General, the Governor of Iowa, and the Territory of Guam, filed an amicus brief asking the Court not to approve the consent decree's short time period. And given these major economic issues, it's not good enough for the EPA to say that it lacks sufficient information to quantify the negative effects of its regulations. It needs to collect that information before imposing the rule to make sure the benefits, in fact, outweigh the costs. If the EPA needs more time, then it should take it, instead of gaming the system by entering into a consent decree that shortens the time for review. Thank you again for the opportunity to address these issues.
Thank you. And even though I didn't limit you to 5 minutes, you were perfectly prepared to deliver for 5 minutes. I'll now recognize myself for 5 minutes. The chart up there, I think you're probably familiar with it, General. It's a little deceiving, though, for anyone watching it here. That large blue line represents that nearly 1 million comments. The two others, I'll read them because they look like they're not there, but there's actually lines there, represent 214 comments in the case of the middle one, for which there was 344 days of comment of intervening period to evaluate. And then in the case of Casper, 3,907, in which there were 278. Is there any logical reason, from your experience, both as an attorney and as a representative of your state, that you wouldn't have for nearly 1 million at least as much time as you had for 214 comments?
No, not a logical reason, no.
Well, then what do you think the reason is?
Well, it's hard to escape that this is being crammed forward, and I understand there's policy goals, but given the impact, and I would venture to guess, having not read all 960,000 comments, that
I'm sure no one has yet.
well, I'm sure they even combined, no team has, that they probably relate primarily not to mercury, even though that's where this all begins, because of the massive impacts across the economy and across the industries that are affected.
Well, I'm going to put up another piece on this. Can you get that diagram up? Yeah. This one baffled me a little bit. Perhaps you could help explain it. When we're looking at health-related items in this new standard, if I read correctly, that little sliver of red there, that's the mercury that's going to be affected. Well, all of the blue area represents particulates. Is that your understanding of basically what we're dealing with here?
My understanding is that nearly all, and that's consistent with this graph, of any alleged health benefits are going to come from the non-mercury elements of this rule.
So most of the technology that has to be developed and implemented almost overnight, and most of the cost is going to come from, if you will, the comparatively not harmless, but particulate, not, in fact, mercury, as so many people are alleging.
That's correct, and the technology necessary to achieve the mercury benefits, if left to stand alone, is a lot simpler and cheaper to utilize than what's necessary for the whole package. I'm sure that's no surprise, but it also would cut dramatically, though it hasn't been quantified, into the shutdowns of plants.
Well, let me ask one more question, because you've looked at the regulatory impact much more than anyone on the dais has. My understanding is that when EPA's mandate to regulate particulates comes under NACS, a whole different discipline.
Right.
Doesn't it appear here as though they're combining 99-point-some% of this bill's effect under a section and a review process that isn't appropriate?
Oh, absolutely. I mean, none of this is beyond EPA's reach through more explicit authority that they have elsewhere in the Act. And yet it has been put in, I know there's always or often in legislation, there's sort of catch-all phrases and whatever else you think might be unhealthy kind of language. But when what gets crammed in there, along with the mercury, is explicitly addressed somewhere else, it seems highly inappropriate to address it this way.
Well, a couple quick follow-ups. One of the ranking members from Virginia mentioned the 160,000 lives that the Clean Air Act saves each year by EPA figures. Many of the estimates appear that at least 280,000 jobs will be lost as a result of this legislation in its current form. How does that impact your state of Virginia?
Well, again, I'd point to Virginia will be affected differently in different parts of the Commonwealth. And if you go to Martinsville, where we have over 20% unemployment, there's a lot of lost manufacturing there from the NAFTA era that we are rather hopeful, if we can get an economic uptick and keep stable and relatively cost-effective energy prices, will become a manufacturing area again. This forecloses or makes it much more difficult for that to happen in that poor swath of Virginia where unemployment is particularly high. I already mentioned what happens in Southwest Virginia, which is not a rich area either. And
you're known for clean coal, but this would still be coal that would be offset.
Yes.
Back to manufacturing. I mean, I wanted to focus on this because I'm a former manufacturer myself. The nature of American manufacturing, as I understand it, is we take affordable energy and we leverage it to compete against less expensive labor in third world countries. And this essentially would take your maybe 2 cent a kilowatt hour power and increase it by maybe 3 or 4 times. It's a huge increase if your base fuel is coal and it becomes natural gas. Isn't that correct?
It certainly is. I can't speak to the exact degrees of increase, but there's no question that the state we're in, it's much more marginal for us to become economically competitive, and anything close to the types of change that you've described makes us uncompetitive with large swaths of the world.
Thank you. And my time has more than expired. I yield to the ranking member.
Thank you very much, Mr. Attorney General. It's good for you to be here. I'd like to put into the record, I'd like to have entered into the record a joint statement from the Attorney General of the State of Maryland, my state, Doug Gansler, and Robert M. Summers, the Secretary of the Maryland Department of Environment. The statement asserts that Maryland has successfully implemented a law that required major reduction in mercury emissions from coal-burning power plants. Maryland power plants have already reduced mercury emissions by 88% without affecting reliability, and in doing so has created jobs in Maryland. I ask that that be a part of the record.
Without objection, so ordered.
Thank you, Mr. Chairman. Mr. Attorney General, it's been documented that exposure to toxic pollution from power plants such as hydraulic acid, mercury, arsenic, and other metals causes a wide variety of health conditions. These include asthma, which I suffer from, and other respiratory ailments, developmental disorders, neurological damage, birth defects, cancer, and death. Do you disagree with any of those findings?
Oh, I'm really not in a position to give you a medical assessment. I'm just here to talk about the legal side. And
I understand that, but you are sworn to protect the people of your great state, are you not?
Sure am.
And I would think that you would be taking into consideration anything that might cause the deaths, particularly from all of these different things.
Certainly.
That's why I asked you.
Certainly.
I'm not trying to take you out of your
Certainly
purview.
would take those things into consideration, always looking for a balance.
Sure. Now, it has also been reported that among industrial sources in the United States, coal and oil-fired power plants emit the most toxic air pollution, accounting for nearly 50% of all pollutants in 2009. Do you disagree with that?
Not in a position to disagree. I would note that we have some co-located among our utilities, oil and coal. And one thing we'd have loved to have seen, because we use the oil very infrequently, only when we have peak demand, if those had been excluded from this rule, that's one way they might have provided more flexibility for peak demand while still achieving many of the pollution reduction goals that they've set here, but there was no exception made for that.
Now, it has been estimated that the proposed air toxic rule would save up to 53,000 lives by 2016. Have you heard that? Are you familiar with that?
I've heard that, yes.
And do you have any reason to disagree with that estimate?
It strikes me as quite optimistic, yes, but it's such a large number, but I haven't done any independent research on that, no.
Now, Mr. Attorney General, I understand that you asked a Federal judge, I think you testified to this, to delay the final air toxics rules for 1 year, making many of the same arguments you've made here today. Was that in the form of a brief, or?
It was, yes.
And are you aware that the air toxics rules have been legally required by the Clean Air Act since 1990, 21 years ago?
I am aware of that, yes.
And I'd like to enter into the record the order of the judge denying this request, and the arguments, the same arguments we're hearing here today, have failed legal scrutiny, and Congress should not be giving them but so much weight. And I would ask that be admitted in the record.
Without objection, although I would note that it went hand in hand with the 30-day extension and may not be germane 30 days from now.
I understand. But these are basically the same arguments. Is that right?
That same judge told the EPA that if they need more time, they could come back and she'd grant it. So it is not, from our perspective, a closed question yet.
I understand. With that, I'll yield back.
I thank the gentleman. And we now go to the gentleman from the coal-producing alternate capital, Cleveland, Ohio, Mr. Kucinich.
Happy birthday, Mr. Chairman.
Thanks, Dennis.
Mr. Attorney General, welcome to this committee. As Attorney General, isn't part of your responsibility to protect the residents of Virginia and not put them at greater risk for illness or even premature death due to air pollution?
Certainly, protecting the people of Virginia is an important part of my job, yes.
Is it your responsibility to protect the people of Virginia from air pollution-related illnesses that could cause premature death?
Part of what we do in my office is enforce environmental laws, and we are aggressive about doing that, so yes.
How many prosecutions have you had of environmental polluters since you've been in office?
Ordinarily, the way those are resolved is with joint decrees that involve the EPA. I don't know how many. I know that we have had a regular flow of them since I have.
Have you recommended prosecution for polluters, and how many have you recommended? Could you be quite specific?
We have resolved all of them with consent decrees, meaning those who are defendants essentially admitted liability.
We meaning who, Mr. Attorney General?
Inevitably, it is our Department of Environmental Quality, which we typically are negotiating on behalf of, and the EPA.
Have you ever been involved personally in any negotiations related to resolving pollution complaints over air pollution?
My personal involvement has related to approving those resolutions negotiated by the attorneys in my office and with the EPA and with the defendants in question.
And do you know what the outcome of those have been? Have they been consent agreements that have, on behalf of communities that have had complaints about pollution?
Yes, That's exactly how they've been resolved, with typically fines and requirements going forward enforced by court order for additional care to be taken, specific steps.
So your office has been instrumental, you're saying, in causing polluters to be fined.
Yes.
Do you have any information you could present to this committee right now about specific cases?
I do not bring specific cases.
But you could produce, will you produce for this committee a list of such cases?
I'd be glad to.
Could you tell members of this committee, and I was particularly interested in your some of the equations you were talking about. You said that clean air standards, I'll paraphrase it, that they can cost jobs. Is that
Sure.
your position? What kind of jobs do they cost? Could you be specific as to the types of occupations?
Sure. Well, for starters, the most obvious is, since we're a coal state, Southwest Virginia and the coal industry is affected. And unlike, say, the part of Virginia where I'm from, Northern Virginia, which has a fairly diverse economy, there's not an economic alternative in Southwest Virginia. So there's that challenge, which is the most overt. Then comes the industries and businesses reliant on energy as a major component of their costs. And certainly any manufacturing that would take place, which we have in Virginia, primarily, though not at all exclusively, in the southern part of Virginia and up the western part of the state, though, again, it is scattered.
Isn't it? Thank you. I just wanted to, you're saying that they cost jobs by definition in the coal industry. That's your position?
Oh, well, sure. I assume that's.
Well, here, but is it possible that if you don't have clean air standards, that it could also create health problems for people?
Sure. That's the trade-off here. That's the trade-off.
Now, is dirty air good for poor people? Because there'll be less poor people if the air is dirty, or is it good for poor people because there'll be less poor people if there's dirty air?
Dirty air isn't good for anybody. Jobs are good for everybody.
And can you tell me, if you're looking at job calculations, about the jobs that are created by poor air standards? Can you think of jobs that are created by poor air standards?
Well, the comparison that we are looking at, and it isn't our own, we're sort of swallowing all the studies, or as many of them being done, is compared to where we are now versus what is proposed. We're not suggesting anything ought to be undone, though I do think it would be far more appropriate for EPA to decouple some of the elements of the rule they're now proceeding on.
Thank you, Mr. Chairman. I just wondered if the gentleman was including in his advocacy the jobs that are created for undertakers when people don't survive as a result of poor air standards.
No.
The gentleman may respond if you'd like.
Sarcastically or in general?
You're the witness.
Yeah. No. We're trying to look at this in the aggregate. And, as I said, the one overt industry that can really be addressed from a Virginia standpoint is the coal industry and the spin-offs there. And after that, it becomes the energy costs associated with the gradual rise in costs as those are incorporated through the utilities, because the utilities pay none of this, none of this. It is the ratepayers who pay for all of this.
Mr. Chairman, I appreciate you giving the gentleman a chance to respond, because he talked about the aggregate, which is what we've been talking about, because we're saying that 17,000 lives a year are on the line with respect to these regulations. Thank you, Mr. Chairman. Thank you, Mr.
I thank you both.
Yeah.
We now recognize the gentleman from Virginia, Mr. Connolly, for 5 minutes.
Thank you, Mr. Chairman, and welcome again, Mr. Attorney General. Do you know what the National Capital Region, including Northern Virginia, is classified as a non-attainment region in terms of air pollution. Do you know what percentage of that air pollution is migrating pollution from coal-fired power plants?
I do not.
Would it surprise you to learn that about a third of the air pollution in this region is attributed to those migrating pollution sources from coal-fired power plants not in this region?
Well, I certainly wouldn't expect everything we deal with in this region to have started here. So I grant you that. But the specific numbers I can't really suggest.
But certainly, as the Attorney General of Virginia, representing, as you point out, all of Virginia, you could understand some of the anxiety and concern in the northern part of the state with respect to pollution caused by coal-fired power plants.
I don't think that concern is quarantined to Northern Virginia. I think it's shared across Virginia.
Point well taken.
What is additionally shared is just a desire for balance to be achieved as we gradually try to keep our air cleaner and improve the standard of living in this country.
Mr. Attorney General, the proposition here is that should this regulation go into effect, it would have devastating effect both on sources of electricity and on jobs. In 1990, with the Clean Air Act amendments, similar arguments were made. Do you know what happened to the price of electricity in the Commonwealth of Virginia in the intervening?
Back in 1990? No.
No, in the intervening 21 years. Did it go up or down?
I can speak to you back through the last decade or so, but I can't go back to 1990.
Would it surprise you to learn that actually electricity rates in the Commonwealth of Virginia in that time period have actually fallen by 35.6%?
Would not entirely surprise me. No.
Well, does that not call into question perhaps then the claims that in this particular case that won't work, and in fact electricity rates are going to go up?
Well,
given the experience we've had in the last 21 years, why should we put credence in such an argument?
Certainly, it would be a lot easier to analyze that argument if there were more than 134 days to look at 960,000 comments, presumably not all of which are substantive, but if you just compare them to other rules. I mean, you all had your own here from this committee. I would look at some others, like the chemical recovery combustion was 2.5 years, reciprocating internal combustion engine 1.5 years, for cement, the Portland cement manufacturing.
Mr. Cuccinelli.
We're looking at 4.5 months to consider the very questions you all are lobbying this way with assumed answers.
Mr. Cuccinelli, unfortunately my time is limited, but certainly the Clean Air Act amendments of 1990 were far more sweeping than what's in front of us now. What happened to electricity rates, for example, in other coal-fired power states with coal-fired power plants? And I'll list them: West Virginia, North Carolina, Pennsylvania, Ohio, Kentucky, and Alabama. Are their electricity rates in the intervening 21 years since that sweeping set of amendments, are they higher or lower relative to 1990?
I don't study other states' electricity specifically. I study the national and compare it to Virginia, unless something borders Virginia and we have a rate case where that's relevant.
Would it surprise you to learn they're also cheaper?
No, I wouldn't be surprised either way, not knowing it. So,
Mr. Cuccinelli, correct me if I'm wrong, I was under the impression that, for example, on the Health Care Reform Act, the Affordable Health Care Act, you were an advocate for nullification. You supported legislation. You supported legislation in the General Assembly of Virginia that made universal mandates illegal in the Commonwealth of Virginia. Is that not correct?
Nullification is an incorrect term, and it suggests you don't know history. Nullification is when a state says, we're not going to obey your Federal law. That isn't what happened in Virginia. The General Assembly, on a bipartisan basis, passed a law. 2 weeks later, the President signed PPACA, and those two were in conflict. And as our constitutional structure provides, we went to court to resolve the disputes of authority related to those two laws. That is not nullification, Congress.
Would you stop the clock? If the gentleman would suspend.
Yes.
General Cuccinelli, you can answer any question you choose to answer. However, you're only bound to answer questions that are within the germaneness of the subject for which you were brought here. You may continue.
Mr. Chairman, if I may.
Of course.
The purpose of my question was not to focus on health care. It was I wanted to give the opportunity to the Attorney General to explain his position, because my question has to do with whether he, if you don't like nullification, then I'll call it preemption. Does the Commonwealth of Virginia have a similar preemption right, if you don't want to use the word nullification, with respect to this regulation, in your view as the Attorney General of Virginia?
I think the Commerce Clause very clearly gives the Congress and therefore the Federal Government the broad power to address something like pollution across state lines, whereas if you compare that to the health care example, ordering a particular individual to go buy a product, not regulating them once they're in commerce, but ordering them into commerce, is a completely different comparison. So I have no constitutional complaints with what is going on in terms of the exercise of Federal authority here. My concerns are policy concerns and legal process concerns.
Yeah.
And
So you see the two as different.
Processes, oh, absolutely. We put those processes in place to protect not only the rights, but to achieve the best policy outcomes. And I know, regardless of the opinions here, everyone here would like to achieve the best possible outcomes for this country. I think that we're more likely to do that if we actually take a legitimate amount of time to consider the material that's now before us that is simply, it's not humanly possible to consider all the comments that are now before us on this rule in the incredibly short time frame.
Thank you, Mr. Attorney General, and thank you, Mr. Chairman.
I thank you. I now ask unanimous consent that we be able to place into the record the details of the 1990 Clean Air Act showing a 5-year period for a rulemaking exception. Additionally, I would ask unanimous consent that the statement by the Union for Jobs and the Environment, these public comment, utility, these are all union organizations combining, that says EPA data implied that no coal unit in the United States meets all the proposed new sources HAPS standards, regardless of the type of coal consumed or the effectiveness of its pollution control devices. And again, that's Unions for Jobs and Environmental Public Comments. And with that, I would now recognize the former chairman of the committee, Mr. Towns. Wait a second. Did I get it wrong? I apologize. I now recognize the distinguished lady from the District of Columbia, Ms. Norton. I'm sorry, I didn't see which one came first. I apologize.
That's all right, Mr. Chairman, and I thank you. Welcome, Mr. Attorney General. There appear to be two separate forks to your complaint. One is the process, the time for the process. I'd like to get to the substance, because it would appear that some states already implement stringent mercury emission limits that are even more stringent mercury emission limits than EPA is now proposing. So I went to a set of states close by the way, Connecticut, New Jersey, New Hampshire, Massachusetts, and New York. Now, here's what the Massachusetts Department of Environmental Protection said. Experience in Massachusetts in imposing stringent emission limits for mercury and other pollutants clearly shows that EPA's proposed limits are achievable and effective. For example, although Massachusetts mercury emission limits for existing coal-fired power plants are considerably more stringent than those proposed by EPA, Massachusetts facilities have been able to install control equipment with no impact on reliability of electric power and have demonstrated consistent compliance with the limits. Now, Mr. Attorney General, aren't those same technologies available to the State of Virginia, for example?
Well, presumably they're available everywhere, Congresswoman.
Well, have you considered the possibility of using those very same technologies to achieve the results in Virginia that have been achieved, even beyond those that the EPA is proposing by nearby states?
Congresswoman, I think you're focusing on what amounts to less than 1% of what the EPA is doing, and that is the mercury piece of this. The mercury piece is a lot more achievable with a lot less damage than if you pile everything else on top of it. And all your statements with respect to mercury, I just accept them as stated and would suggest that it wouldn't cause nearly, not on an order of magnitude, the kind of challenge that the whole rule that EPA is advancing.
Well, but Mr. Attorney General, the Northeast states for coordinated air use says of EPA's proposed rule, and here's what they say of the rule itself: the successful track record demonstrates that there are no insurmountable technology, cost, emphasis on cost, or at least I put the emphasis there, as you appear to, or timing barriers to achieving EPA's proposed mercury and air toxics standards. Now, they're speaking beyond the mercury standards. Do you disagree with that statement?
I'm not quite sure what they mean by the air toxics. I assume they mean the acid gases, which you've got the mercury acid gases, you've got the particulate matter. So if you take the PM,
well, they say air toxics, so I assume they're talking about all the air toxics.
Well, if they're talking about all of them, then no, I would not agree with that statement. If they were strictly speaking of the mercury piece,
well, they're not strictly speaking of that.
I do think the mercury piece is probably within reach.
And you think that Virginia could, in fact, then move forward on the mercury piece?
If you strip the other stuff out and just
well, but these people went ahead on their own, Mr. Attorney General, because they care about the health and welfare of their people, and they are beyond what EPA is now proposing. So you're going to wait for EPA?
No, ma'am, they are not. They are beyond what EPA is proposing in the area of mercury and mercury alone.
So they are beyond what they are proposing in mercury alone?
Yes.
They went ahead before EPA proposed. I'm asking you, don't you think Virginia might go ahead before on mercury alone, since you think that is achievable?
Virginia could do that, but it obviously has made the policy decision not to do that. I would note that this all has, as I said before, the balancing consequences. We have a much lower unemployment rate than any state you just named. We have a higher economic growth rate than any state you just named, despite the economic challenges.
Well, Mr. Attorney General, I don't know if that is the case, and I will not accept that until I look at those figures. But let's look at your concern with the process.
I ask the gentlelady have an additional 30 seconds.
I thank the gentleman. Are you aware that the rule finalized, apparently to be finalized in December, you'd not have to comply with until 2015, and then extensions could be gotten after that if you demonstrated that an extension was necessary?
I'm aware that if the rule goes into effect in or is approved in mid-December, it would go into effect in January and have a 3-year implementation timeline. I also know what it takes to replace, to permit, do all the steps necessary for the utilities in my state to replace certain power generation that will have to be withdrawn in that time period, and we can't match the two up. We can get kind of close, but not match them up.
In which case an extension, it seems to me, would be justified. Well, thank you, Mr. Chairman.
The extensions would undoubtedly be helpful. That's always true. However, there is a limit on the EPA's authority to just extend, and relying on that from a business planning standpoint is not something that I can argue before my State Corporation Commission when the utilities come in and say we have to meet this. They don't have to rely on the extension, and the law of Virginia, as dictated by the U.S. Constitution, because they're granted a right of return, is that those rates will pass through to all of our citizens, poorest, richest, and everyone in between.
Thank you, Mr.
I thank the gentlelady, and I thank the Attorney General. With that, I recognize the former chairman of the full committee. Oh, I'm sorry. We have, Chairman, you're just going to have to wait 1 more minute. 5 more. With that, I recognize the gentleman from Oklahoma for 5 minutes, Mr. Lankford.
Thank you, Mr. Chairman. And I do apologize for taking a little bit of the former chairman's time, I guess, there and jumping in between.
We'll make it up to him.
That would be great. Thank you for being here, Attorney General. Glad for you to be able to be here. My concern is that if I went back 35 years ago, in Congress was conducting hearings and conversations about pushing power generation out of natural gas into coal and into nuclear, because we were, quote unquote, running out of natural gas. And so no more natural gas power plants out there. Folks that were using that need to go into coal. Now, plus 35 years, now the Federal Government is saying, no, coal might not be a good idea. Let's try natural gas and see how that works and see if that's better, or see if we can use wind. And as we continue to adjust and at the preferences of the Federal Government, and now to use a series of studies to be able to justify how we want companies to be able to move, that's very difficult on power generation, who can't just plan for next year. They have to plan for next decade on what they're going to construct. My concern is the cumulative effect of all of these regulations, and if that has been evaluated, is it your opinion of all the things that are coming down, and I've got 3 pages worth of different regs that are coming down right now out of EPA on power generation, whether that be 316B, whether that be the cross-state rules, whether that be whatever it may be for coal. And there's a whole litany of different issues from coal from the time it comes out of the ground all the way until it's fly ash at that point at the end. Do you feel like that has been adequately studied in this hurry to be able to get through this almost a million different comments that have been made in it? Was the cumulative effects also evaluated in this?
If you're asking me, do I think it was done adequately? Absolutely not. I mean, and this hasn't even gone to OMB yet, and they are still setting a finalization date in the middle of December. That's normally itself a 90-day process. And, of course, it's November now. So that isn't going to happen if they're going to keep to the schedule they've laid out. And that has absolutely not been looked at. And you mentioned something that triggered a thought, and my Congressman had mentioned it earlier with respect to greenhouse gases, and I think of the switching of fuels. You know, the fact that we had sued EPA over their improper process or in the greenhouse gas endangerment finding was raised by earlier. And what's interesting about this is if that's so important, this makes it worse. And that hasn't been looked at either in any serious way. Or maybe it's buried in those 960,000 comments, but it seems the timeline has been set up so that they won't be reviewed, not that so that they will.
Right. And that is my concern, is that there has not been enough time to be able to go through this. The President has been very urgent to say we need to look at cumulative effects of regulations. If that has not occurred, to be able to gather cumulative effects of all these different regs that are coming down and the speed that they're coming down and the size of them. One of the statements that was made by EPA was that this may have a potential of, what is it, $10.9 billion in annual cost on the economy. Well, just that one regulation alone, $10.9 billion. Then you start adding to it all the different areas of 316B and everything else that's coming down on it. It's fairly significant what's happening. And I understand previous comments that have been made to say we continue to add regulations to the power industry, but the power continues to go down. I would presuppose at some point that doesn't work anymore. You can't just throw in 1,000 regulations and say we're going to continue to drive the cost down by adding more regulations. It doesn't work that way. At some point, you've got to have some common sense. Agree or disagree with that concept?
I would certainly agree with that, and I would also note that Executive Order 13563 requires EPA and other regulators, and I'll quote, that's why I'm going to read my notes, to tailor its regulations to impose the least burden on society consistent with attaining regulatory objectives, taking into account the costs of cumulative regulations. And EPA has not performed a cumulative regulation cost analysis for the utility MACT.
Okay. What about the effect on reliability of power in the days to come?
I understand that is widely debated here. It's not much debated in Virginia. We're looking at, just for one of our utilities, probably $250 million of transmission infrastructure costs. And again, those by law pass right through to the ratepayers. But on top of that, from a public policy standpoint, I was in the State Senate. These are the ones people scream about. This is where power lines are going to be built across 50, 60 miles of people's backyards that do not now exist and are going to be necessary to provide the flexibility in the grid to meet the reliability requirements that you'd expect of a modern electrical grid. So we're also looking at that challenge. We haven't talked about that at all.
Right. Well, I would say, again, if we're going to make a major decision that's going to affect billions of dollars and it's going to affect future planning, we better make it right. You go back 35 years ago when we said, let's go to coal because that's more abundant than it is for natural gas. Now we're trying to reverse that. Obviously, we should have done more studies 35 years ago instead of doing a knee-jerk reaction. We do the same knee-jerk reaction again, we're going to have the same kind of consequence if we don't do this right. So with that, I yield back.
I thank the gentleman from a major natural gas producing state. And with that, we recognize the chairman, former chairman of the full committee, whose picture adorns the area just behind us, Mr. Towns, for 5 minutes.
That only means I've been here a long time.
Okay, we'll make it 6 minutes.
Mr. Attorney General, you testified today that one of the impacts of the air toxic rule will be closure of coal-fired power plants, which will in turn cause job loss. Is that correct?
Well, and with the increased electricity cost that comes with it, yes.
But evidence from our previous hearings on this subject before the Subcommittee on Regulatory Affairs suggests that many of these coal firepower plants are older and would have gone out of business anyway. What's your answer to that?
I think that you are certainly accelerating the retirement of part of the coal fleet. I don't think in a way that the utilities envisioned necessarily, but certainly that will be where they try to sacrifice some of their generation. That's just logic.
Let me ask you this. In a meeting on June the 1st with investors, the chairman of American Electric Power, a gentleman by the name of Michael Morris, told investors the following, and I quote, "As you know, those are high-cost plants. Throughout almost all of 2009, those plants probably didn't run 5% of the time because of natural gas prices. When we shut those down, there will be some cost saving as well. And on balance, we think that that's the appropriate way to go." What is your response to that?
Well, for starters, I'll circle
Do you
back
agree or
to
disagree?
something, and we have, our second biggest utility is one of their subsidiaries. APCO is an AEP subsidiary. The 5% comment, we have some plants that fit in the category he described. I used the oil-fired as an example. And mind you, there is some value to keeping fuel flexibility. And just even if they're dirtier plants, even if they aren't what you'd want run all the time, to have them available for peak time in the winter and the summer is, I would suggest, of great value on both a cost basis and a reliability basis that far outweighs the benefits you might get by shutting them down permanently, which is, as his comments suggest, what is going to happen. And I think when you moving them perhaps from a run 24/7, 365 position to using them as peak power would be a great alternative for America. It would achieve, even if you just accept all the health claims, everything, without disputing any of that, just moving them from one position to the other would be a huge boon, and with tremendous cost savings from an opportunity cost perspective that aren't dropped on ratepayers because you move them over instead of shutting them down. But that is not an option under this rule. It is not an option under this rule. It is, in fact, the opposite, where you'd have to put in all the upgrades, whether you're going to use them 100% of the time or 5 for a 5% plant. So, of course, you're going to shut it down.
Let me ask, AEP plans to close 2 plants in Virginia, I think Clinch River and Glen Lynn. Is that true?
Well, I don't know. I can't speak for AEP, but I certainly would expect that they're on the blocks, yes, for this.
And AEP agreed to retire those plants under a 2007 consent decree over violations of environmental laws. Isn't that right?
I don't know that shutting them down was part of any consent decree.
Let me, I know my time is about to expire. Mr. Attorney General, it seems to me that your testimony before us today is a transparent attempt to blame the government for the fact that many high-cost, dirty coal plants could not compete in today's market even before the air toxics rule goes into effect.
But then they'd be shut down of their own course.
You know, and I know your answer has been that you only represent Virginia, but when you actually in the position of Attorney General, you do have to look at what happens in other states as well, and then you make an opinion, actually evaluate as to whether it's good, bad, or indifferent. You have to compare it with something. So I want you to know that you do have to look at other states. You just can't look at Virginia.
Yeah, my comment to that effect was only with respect to the specific data from those particular states. I agree with you that you've got to draw from the experiences of other parts of the country and other states, and I do that in trying to do what's best for Virginia.
I yield back, and thank you very much for coming to testify.
Thank you. Let me make just a quick comment as well. Then I'm going to take just a quick moment and then yield to Mr. Connolly a quick moment, and then we're going to conclude this panel so we can make a transition as well. And just a comment in this as well. There are 25 other states, obviously, that are represented in this brief. That it's not just Virginia we're talking about at this point. So this is not just a single state issue. This is a national issue on it, and all that is happening. And that currently, what is in place on this is not just dealing with a small group of plants that are very out of date, but there are no coal plants that can abide by this nationwide. No one is at that standard at this point. And so that's the challenge, is try to figure out what do we do with this that no single utility will not be affected by this process on it. A quick question for the Attorney General on it as well, and that is dealing with the combined regulations. As we talked a little bit before about the cumulative effects of this, the American Coalition for Clean Coal Electricity estimated that some of the combinations here, we're talking about an increase of electricity of somewhere between 12 and 23% on it. I know we were guessing earlier on some figures. 12 to 23% hits the poor pretty tough, especially. What numbers have you seen? What estimates would you put out?
In our last round of utility rate cases, and we're now awaiting orders in what is the second round since I've been Attorney General. But in the last round, we actually analyzed the rate increases as it related to Federal, not State, just the Federal environmental regulation, and about 35 to 40% of the base rate increases were pass-through of these environmental costs. In Virginia, unlike, say, North Carolina, our utilities can absorb these costs as they incur them on a rolling basis. In North Carolina, utilities can't incur them until they flip the switch and throw the new plant online, which, of course, builds up costs, and it keeps their rates a little lower for a while, and then they spike. So it happens a variety of different ways, but it goes up. And I've only had to have a couple of town hall meetings as Attorney General, and they were both on utility rates in the poorer parts of our State, because it's hard to describe from people who are not from poor parts of a State what utility rates mean to the people in these households. When you talk about $10 a month or $20 a month more, it's real money. It's real money in a small house that's pulling maybe 1,250 kilowatts, which is an APCO average. That's big dollars to them. It hurts when they're on fixed incomes, as a large swath of that portion of Virginia is relative to the rest of Virginia. We see that a lot, again, in the poorest parts of Virginia. And make no mistake about it, there are going to be economic consequences. There's always a trade-off. You all make these decisions all the time about where these trade-offs should land. But make no mistake about this. The people hurt first and the people hurt worst economically are the poor. They are the poor. That's who you're going to hurt first, and that's who you're going to hurt the worst. Thank you, Mr. Chairman.
Thank you, Mr. Attorney. With that, I yield 3 minutes to Mr. Connolly.
Thank you, Mr. Chairman. I would note that the Attorney General's view of history and mine might be slightly different with respect to utility rates in even the poorer parts of Virginia. Many of the rate increases he is referring to occurred subsequent to the re-regulation legislation passed by the General Assembly of Virginia, highly favorable to industry, not particularly favorable to consumers. Mr. Attorney General, let me ask you just one question. You talked about utilities. The largest utility in the Commonwealth of Virginia is Dominion Resources. Has Dominion Resources requested that you challenge the air toxic rule legally, or that legislation be introduced to try to prevent it from being implemented?
No. As I mentioned earlier on your mischaracterization of nullification, Virginia isn't in a constitutional position to step in on Federal environmental regulation of this type with a constitutional objection, even if we had legislation. The Supremacy Clause of the Constitution has Federal law trumping State law. The health care case you asked about earlier, the Supremacy Clause contains an exception when the Federal law is not constitutional. No one I'm aware of is alleging that what EPA is doing here is unconstitutional, inappropriate, incredibly unique in terms of the speed particularly in light of the volume of the comments and the potential impacts, which, even if you accept the EPA's perspective, are still wildly in dispute?
So the answer is that so far that largest utility in the Commonwealth has not asked you to seek to overturn the rule. I mean in the Federal level.
I'm sorry, you mean in the what?
At the Federal level. I'm not referring to nullification. Have you received, as the Attorney General of Virginia, any communication or indication from the largest utility in the Commonwealth that it would like you or others to, in fact, try to seek to overturn this pending rule?
No. My concern is more with ratepayers than it is with the utilities.
Thank you. And, Mr. Chairman, I just end my colleague from Virginia and I do disagree in terms of interpretation of history. Frankly, when a State seeks to preempt Federal law and to argue on its own that that law is in advance unconstitutional, is nullification by any other sense of the word.
Not if you know what you're talking about.
I think I do know what I'm talking about, and I think you have an agenda, Mr. Attorney General. It's just one I happen to disagree with. With that, I yield back.
With that,
Chairman?
Yes, sir.
Before you end the hearing or recess the hearing, I wanted to take just a moment, if I may.
Certainly may. We had 3 minutes going all the way around, so absolutely.
Mr. Attorney General, I want to thank you for your presence here. I want to thank you for working for the interests, like nearly half of all attorneys generals have, to try to make sure that we get this new regulation right. I appreciate your being calm and deliberative in explaining what your goal is, what Virginia could do more expeditiously, and quite frankly, the need to have nearly 1 million public comments evaluated in the way that is appropriate before we set a regulation that people may ask for extensions on, but which may in fact be a different regulation than if all these comments are properly viewed in a public way. So your attention here, your willingness to come on short notice, we very much appreciate. And again, I appreciate people willing to come before this committee. It's not always pleasant, but your testimony was essential. I yield back.
Thank you, Mr. Chairman. And with that, we'll take a short recess so we can shift to the next panel.
Thank you.
The hearing will reconvene. We now recognize the Honorable Robert Persichetti. He is the Deputy Administrator of the United States Environmental Protection Agency, and it's an honor and a pleasure to have you here today. Pursuant to the committee rules, all witnesses are to be sworn. Would you please rise to take the oath and raise your right hand? Thank you. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect the witness answered in the affirmative. Pursuant to the normal routine, I know you have 5 minutes or more to give. Your entire statement will be placed in the record. You may read off of it, or you may summarize it, and we'd only ask that you try to remain fairly close to the 5 minutes to allow time for questions. And with that, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and Representative Conley, and members of the committee. I appreciate the opportunity to appear before you today on the mercury and air toxics standards.
Is your microphone on? Can you hear?
I'll move in.
Oh, good.
Okay, I'll move in a little closer. EPA's clean air power plant rules are necessary to protect public health and the environment from pollution produced by these plants, especially the oldest and dirtiest and least efficient of them all. The EPA will issue a final mercury and air toxic standard, which is the topic of today's hearing, on December 16, 2011. We are not the first administration to recognize the need to clean up power plants and to issue rules to address that need. In fact, since 1989, when President George H.W. Bush proposed what became the Clean Air Act amendments of 1990, power plant cleanup has been the continuous policy of the United States government under 2 Democratic and 2 Republican presidents. While past EPA rules have made progress in reducing the harmful effects of pollution, more remains to be done to ensure all Americans have the clean environment to which they are entitled. The two clean air power plant rules, the mercury and air toxics standard and the cross-state air pollution rule finalized earlier this summer, will achieve major public health benefits for Americans that are significantly greater than the costs. These pollution-reducing rules are affordable and they are technologically achievable. There is tremendous public support for moving forward with these rules. Since March, we have received hundreds of thousands, as has already been mentioned, of comments from the public urging us to reduce mercury emissions from power plants. The mercury and air toxics rule will have a significant public health benefit. For example, it will reduce mercury, which can cause neurological damage in children who are exposed before birth. The rule, as proposed, also is projected to avoid thousands of premature deaths, thousands of non-fatal heart attacks, and hundreds of thousands of asthma attacks. This rule would provide Americans with $5 to $13 in health benefits for each dollar it costs. Our analysis and past experience indicate that warnings from some of dire economic consequences of moving forward with these important rules are exaggerated. While not its focus, the mercury and air toxic standard rule has the potential to improve productivity and provide jobs. We estimate that the proposed rule would result in 850,000 fewer workdays missed due to illness and could support 31,000 job years of short-term construction work, the net of $9,000 of long-term utility jobs. Money spent on pollution controls at power plants provides high-quality American jobs in manufacturing steel, cement, and other materials needed to build the pollution control equipment, in installing the equipment, and in operating and maintaining the equipment. And many of these jobs are jobs that will not be and cannot be shipped overseas. In fact, the United States is a leading exporter of pollution control equipment. Our publicly available analysis shows that the EPA rules affecting power plants are affordable. This is corroborated by other outside groups and some in industry who recognize that issuing the rules in the same time frame helps provide power companies with the certainty they need to make smart and cost-effective decisions. As we did more than 2 decades ago, we are also hearing claims that our rules will lead to potential adverse impacts on electric reliability. EPA's analysis projects that the agency's rules will result in only a modest level of retirements that are not expected to have an adverse impact on electric generation resource adequacy. Our rules will not cause the lights to go out. While there are some industry studies suggesting that these rules will result in substantial power plant retirements, in general they share a number of serious flaws. Most notably, as the Congressional Research Service emphasized in August, these studies often make assumptions about requirements of the rule that are inconsistent with and dramatically more expensive than the EPA's actual proposals. In some cases, the analysis were performed before many of the regulations in question were even proposed. In closing, I would like to suggest that the committee should be clear about what is at stake here, and those who have stalled in cleaning up their pollution call for further delays. Delay encourages companies to avoid upgrading America's infrastructure and putting people to work modernizing their facilities, and most importantly, delay means the public health benefits reducing harmful pollution are not realized. Thank you, and I look forward to answering your questions.
Thank you. And I'll recognize myself for the first 5 minutes. And I'll kind of take your opening statement in reverse order. If I understand the nature of every time there's one of these pollutant standards, I just want to understand, you really don't usually do much to the overall facility. It's normally a bolt-on of some additional cleaning equipment. Isn't that true in this case?
Yes, but obviously from an engineering perspective, it has to be integrated into the operation of the facility.
Right.
So
well, and that begs the bigger question. Isn't it true that today there is no utility that you can show us that is able to implement this entire standard today? I know there are pieces of it in various places, but no utility is currently able to implement. Isn't that true?
I don't believe that that is correct. I believe we look at the best performing plants around the country.
Well, and we looked at that, and you looked at each plant, and you put together various plants and said, if you do this and this and this, like Frankenstein, you can get one person. But you make the assumption that you can put together the best of all these plants. Some of these plants have different non-combinable operations at the current time. Isn't that true?
I believe that plants can meet these standards, and some do. But I would like to.
Now, is there any plant that meets the standard today? You said some do.
I believe they do. But I would.
If you'll answer for the record of a single plant that meets this standard today, we would be thrilled to hear that, because we just had an Attorney General, one of 24, I'm sorry, who have asked for a delay, as you know, in order to get public comment, but most importantly, have asserted, as does, and I'll put it in for the record, the Unions for Jobs and the Environment public comments, a union, combined trade union organization, who believe that today there is no standard. Isn't it not uncommon that the EPA believes that a standard will be, the compliance with a standard can be achieved within the time parameter, and that it might be, and I want to give the benefit of the doubt, it might be that they could achieve it by 2015. Isn't that part of the assumption? Not that it exists today, but that if you take all of the analysis, that they could achieve it by 2015.
The air toxic standards that we're proposing for power plants has to be based on available technology that is currently performing at the level that we are proposing.
Okay, so if you will, for the record, have the EPA deliver us one power plant of, let's just say, megawatt or above, that uses coal that currently meets the standard. We would appreciate having that for the record, and we'll hold the record open to receive that. Now, if we could put back up the pie chart. Earlier today, we had one of those 24 Attorneys General who said, although he's not a scientist skilled in this area, but that he believed that when it came to the area that would be under this normal regulatory process, which is the mercury, that incredibly small sliver of pink, that if this standard were only affecting mercury, he believed that a shorter comment period with a great likelihood of achievement was possible. Do you agree with that, that mercury is not what's driving most of the objections from what you can tell?
That chart is correct. The best I can tell, Mr. Chairman.
Okay, I mean, it's from your analysis, but we couldn't resist using your own figures because they seem compelling. So isn't it disingenuous the term we like to use here in Washington more often than maybe we should. But isn't it disingenuous for the EPA to talk endlessly about mercury and its effects, all of which we're very concerned about, when in fact the vast majority of this regulation has to do with particulates, and if not 920 out of 930,000 comments, the vast majority of those comments are about the mercury portion, a portion which is probably achievable well within the time parameter.
The effects of mercury on children affects their neurological systems.
No. My question is very narrow. It's not about the effects of mercury. It's if, in fact, the technology exists today or can predictably exist in time to meet the 2015 as to mercury, isn't the combining of particulate, normally covered by another part of your authority, a fairly disingenuous use of the benefits? Because the benefits of reducing the mercury and the technology to reduce the mercury appears not to be in widespread conflict. In fact, if this was a mercury-only standard, you might likely have much greater support for a much quicker implementation.
You have to let me try a little bit here to answer that question. First of all, we can't quantify all those benefits from those neurological impacts on children. Those are not completely quantifiable, as we are able to quantify some of the fine particle co-benefits. And the reason we have co-benefits is because the pollution control equipment that you would use for mercury, for arsenic, for nickel, chromium, and the acid gases, which are all regulated under the air toxics program, all of which have public health implications, we think having co-benefits is a good thing, and that those co-benefits also have substantial public health benefits. So it is those same pollution control that same pollution control equipment that is making those reductions in fine particles. It isn't like we've asked for a separate control for fine particles. These are the controls that will reduce those other emissions.
And with that, I recognize the ranking member from Virginia, Mr. Connolly.
Thank you, Mr. Chairman. If you wanted to continue, I would certainly yield to the Chairman.
Okay. Very quickly, I just want to run one follow-up. I thank the gentleman. As I understand it, roughly 90% of the benefits that you're claiming under this regulation would already occur under particulate reduction under MACT. Isn't that true? In other words, you're double counting. You have another regulation that would cover 90% of this. You're counting 100% of the reduction in particulate when, in fact, 90% of it's going to occur and most of the benefit. So I guess for the record, would you tell us what the differential between the two standards, that last 10% on particulate, what portion of the co-benefit would actually occur? In other words, the numbers for what is the last little fraction of reduction.
Did you say NACs?
By the NACT program, which is, in other words, the amount of reduction here and the cost, my understanding is that about 90% of the particulate reduction under that part of the regulatory authority is already ordered, basically.
Well, all I can say, what I have to answer here is this rule is aimed at reducing the air toxic emissions. Those air toxic emissions that I mentioned, those metals and acid gases, are associated. The same control technologies are used.
No, I understand that, but here's the point. Much of this standard for particulate is below what you say is safe by your own figures. So under NACS, when you say you get down to this this level, you now have clean air. You've defined clean and safe. And yet in this regulation, you're regulating a standard lower than what you say is necessary. In a nutshell, isn't it true that your regulatory authority ends at the point in which air is safe?
We are regulating.
Now, wait a second. Your staff is shaking no behind you. So if you can answer that you think you have a regulatory authority beneath a threshold which is safe by your own standard, I'd like to hear it.
2 quick points. We are regulating air toxics here, and it's a technology standard that's looking at the best available technology, the maximum available control technology. That's what the MACT stands for those air toxics. It gets those benefits. It gets those co-benefits of reducing fine particle pollution, which we think is great, and there are health benefits even below the standard.
Well, then, the Ranking Member has been very generous, but then why is it you have 15 milligrams per cubic meter per billion, et cetera, You have this 15 milligram standard, and yet you've got your new standard. You're now setting, and that's what you've considered safe on one hand, and then you come in below 11.5 milligrams, M3, and I mean, I can't think in terms of that small, but I agree that particulates, even in these small amounts, are important to look at. But why wouldn't you change your standard? Support it with science, change your standard to an amount below 11.5 before regulating before 11.5 and claiming benefit below 11.5. Doesn't it seem like you've declared clean as 15, and you're regulating below that and taking credit for cleaner? And I'm not a scientist, and I will not claim to have any expertise in this. I can just look and say, there's an inconsistency, like a set of books that don't balance. You may not know where the missing money is, but if they don't balance, you go looking for it. Why not have a standard that is adjusted based on science to match this greater regulatory request you're making?
We are regulating the air toxics here, the nickel, the arsenic, the mercury, the acid gases, the control technologies that we use.
But you're claiming the benefits from the particulates.
But those benefits are real. Those benefits will accrue to the American public.
Then why not lower the standard to 11.5 or below, so that you're consistent in what you say you want to reduce the particulate level?
The National Ambient Air Quality Standard is set under a science process where we have science advisors that advise us on what level is adequate for the protection of public health. It doesn't mean that there aren't public health benefits below that level, and that's what we are looking at here. These are co-benefits from controlling the air toxics that is the objective of this particular rulemaking.
Well, it's clear as mud, but I thank you for your efforts, and I recognize the Ranking Member.
I thank the Chair. Mr. Percipici, I'm sorry. Percipici. The Chairman asked you the question of whether any coal-fired power plants in the United States could possibly be compliant with the proposed new rule. I have a list in front of me of existing coal-fired power plants. It's a partial list that are already fully compliant with EPA's proposed rule, including 4 in my native state of Virginia. Despite the testimony of the previous witness that nobody in Virginia could be compliant, I've got 4 power plants, coal-fired power plants, that are fully compliant today. Are you aware of this list?
I know there are some that are in compliance with the rules. I just don't.
I would ask without objection that this list be entered.
I do know there's a new one under construction in your state.
Yes.
At Virginia City.
Mr. Chairman, I'd ask unanimous consent that this be entered into the record.
And we will be providing information.
Thank the Chair. Is it not also true that nearly 60% of all coal-fired power plants that report emissions to EPA are compliant currently with EPA's proposed limit for mercury?
I don't know the exact number. Perhaps my staff behind me have the exact number.
Again, I would ask that this be entered into the record.
To be clear, we can't base the standard on something that hasn't been met by an existing.
Correct. My point in asking you this question is that this notion that the hobnail voodoo government is going to destroy industry and consumers and cut off the source of electricity in the United States is a false premise, given the fact that 60% are already compliant on the mercury standard. Is it not further true that 73% of all reporting units are already compliant with the proposed limit for HCI?
It's likely.
And 70%, I would ask that be entered into the record too, and that almost 70% of all units are compliant with the EPA's proposed limit for PM, particulate matter.
Yep.
So what we're trying to do is make at the margins an improvement for those not compliant, some of which, as we already heard in previous testimony, are older plants that are probably on the chopping block anyhow and would serve both consumers and the breathing public if they sort of use this occasion to perhaps move on. We also heard from the Chairman concerns about, well, why didn't you just take a lower level? Didn't the previous administration try that tack? And wasn't there a court ruling that it required more rigorous enforcement?
I mean, on fine particles, I think it was on ozone that there might have been a court ruling or court activity, but I don't know about fine particles.
Well,
but the bottom line is that there are health benefits. You're talking about this rule, not
yes, this rule.
Yes, the previous administration. First of all, there's a 20-year.
Please finish your sentence, Mr.
There's a 20-year history here.
Yes, you were just about to say the previous administration.
The previous administration proposed controls for mercury in 2004.
And what did a court of law?
The court threw those out because they did not comply with.
Yes, that is the answer to the Chairman's question.
Yes.
Why are you doing this? It's not unique to the Obama administration. The previous administration tried doing what the Chairman suggested. Why not just settle for a lower level? And a court of law said, not good enough. And it told EPA in a court suit, you have to come up with new regulations. There are tougher than that. Is that not correct?
Well, the court said that yes, that's correct. It had to be regulated under a different part of the Clean Air Act.
Thank you. So that's the answer to why you're doing what you're doing today. A court told you had to, and threw out the Bush administration attempt to have a lower standard. It isn't because you just, in some lab somewhere decided to just be, a pain in everyone's side by coming up with tough, hard-to-reach regulations. And as the data shows, they aren't, since a majority of the units reporting already meet one or more of the regulations. Was this standard on toxic pollutants envisioned or incorporated in the 1990 Clean Air Act amendments?
Yes. The Congress.
Why did it take 21 years then to implement the law passed in 1990, signed into law by a Republican president?
Well, it's hard to imagine that it has taken 21 years to get to this particular point, which obviously flies in the face that we're going too fast. It has been looked at numerous times by EPA. There have been proposed regulations that were not properly completed, and we are in the situation now in this administration of having to be guided by the judicial branch toward the end that we are now aiming at.
Thank you, Mr. Giuseppe, and thank you, Mr. Chairman.
I thank the gentleman. Social studies was a long time ago for me, civics. I'm familiar with the legislative branch. I'm familiar with the executive branch and even occasional executive branch overreach. Sue and settle was new to me until I got here. Does EPA ever encourage groups to sue them?
No. In fact, usually we get sued when we're not doing what Congress asks us to do, and that usually is what results in us getting on a schedule that's different than the schedule Congress set.
So you never invite lawsuits?
No.
And there would never be anything to indicate that you had suggested that someone sue? A friendly lawsuit, shall we say?
No.
Never?
Not that I know
of. What's so talismanic about December 2011?
21 years waiting, health benefits denied.
Well, if we've waited 21 years and we have almost 1 million comments, wouldn't you think we ought to wait maybe 22 so we can fully digest all 1 million comments?
Well, it might be good to say something about those 1 million comments since they've come up, if you would appreciate that. Of those 1 million comments, 900 and something thousand, the vast majority are in favor of the rule. And of those 1 million comments, as you know, some people have systems that they can reply. Only about 22,000 are unique, among, as opposed to duplicates of comments.
Well, 22,000 is still a lot. I mean, it's not 1 million. 22,000 seems like a lot to digest between now and Christmas.
It is a lot, but it's not between now and Christmas. Again, we've been working on this rule for a long time. The comment period, we left the comment period open longer than we normally do. so that we expected to get a lot of comments.
Have you asked the court for more time?
Pardon?
Have you asked the court for more time? This is a court decree, I assume. This is a judgment?
And we recently asked the court for another 30 days to finish the work. We have read every one of those comments, and we will be replying to every one of those comments in the response to comments document that we are currently working on. And we knew that we would get a lot of comments because we left the comment period open longer than we normally do, and therefore we put the staff to task that we would need to be able to review those comments.
Did you have an opportunity to listen or watch the President's joint address to Congress several weeks ago?
I did.
He mentioned regulations, and he mentioned some that are having a deleterious, pernicious effect on industry. Then he said we should have no more regulation than is necessary for the health, safety, and security of the American people. And I think he's identified 500 that, at least 500, that can be done away with. It strikes me as curious, or let me ask before I say it strikes me as curious, are you arguing that the imposition of this regulation is actually going to create jobs?
We believe that the construction jobs and then the operation and maintenance jobs will be a net positive in this sector.
How many coal jobs do you think will be lost?
You know, we expect, one of the things you have to realize is we're investing in coal, the country, not me, EPA, we are investing with this rule in coal-fired power plants. We are going to make a major capital investment.
I probably didn't ask my question artfully. How many coal jobs do you think we'll lose? I mean, you think we're going to add some construction jobs. How many jobs will be lost? Because neither one of us are naive enough to believe there aren't going to be jobs lost.
I expect that the amount of coal that is used will be roughly flat. The plants that we will invest in here, which will be many,
what analysis
will then lock in the fact that we're going to be using coal for many, many, many years.
What analysis did EPA do with respect to job loss?
We have a range that we've identified. 9,000 permanent job gains is in the middle of the range. There's some that go just slightly below zero.
I'm just asking about job loss. I hadn't gotten a jobs gain. What analysis did EPA do about job loss?
The best estimate of the net gain is 9,000.
So EPA did factor in the losses to the coal industry and others?
Yes.
Okay. My time's up. Sorry. I want to thank you on behalf of Mr. Connolly and myself. Give me 1 second. On behalf of Mr. Connolly, Chairman Issa, and myself, thank you. And we will be briefly in recess as the third panel approaches.
Okay. And we will provide the information that I suggested to the Chairman in follow-up. And, of course, every question that you all have will follow up as quickly as possible. Thank you for your time, and I appreciate the questions.
Very well. Thank you. We will be in recess for 5 minutes.
Hearing will now reconvene. We now welcome Mr. Josh Bivens. He is an economist at the Economic Policy Institute. Mr. Bivens, I noticed that you were here for the previous panel, so you recognize that pursuant to our rules, all witnesses are sworn. Would you please rise to take the oath? Raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Once again, let the record reflect the witness answered in the affirmative. And once again, the witness is recognized for 5 minutes for his opening statement.
I thank the committee for the invitation to testify today. My name is Josh Bivens. I'm an economist at the Economic Policy Institute in Washington, D.C. By professional peer-reviewed research standards, the ratio of benefits to cost of the EPA's air toxics rule are very large. But somewhere along the way, the debate moved onto the grounds of job creation, which is a little odd because regulatory changes just aren't big drivers of job growth. But in my testimony, and especially in my written testimony, I sketch out how regulatory change in general and the air toxics rule specifically can affect job creation and unemployment. I conclude that the air toxics rule, like almost all related regulatory changes, will have trivial effects on job growth over the longer run, but that over the next couple of years, particularly if the unemployment rate remains high, the rule will actually on net create jobs and lower the unemployment rate. Further, it's precisely because the unemployment rate is high today that the rule, if implemented as planned, would have clearly positive impacts on job creation. So in short, calls to delay implementation of the rule based on vague appeals to wider economic weakness have the case entirely backward. There's no better time than now from a job creation perspective to move forward with these rules. My research, which I summarize in my written testimony, indicates that the toxics rule or adoption of the air toxics rule would lead to the net creation of about 28,000 to 158,000 jobs between now and 2015. The primary economic impact of these rules will be in significantly boosting health and quality of life, leading to benefits that are at least 5 to 10 times larger than the cost. But since we're here to talk about jobs, or at least that's why I've been asked here today, is to talk about jobs, let me just say a couple of words on it. The job impacts of regulatory changes depend on the wider macroeconomic context. When the economy is functioning well, job impacts from regulatory changes are going to be quite small for two main reasons. The most important reason is just that in a well-functioning economy, the Federal Reserve can neutralize any boost or drag on overall employment growth that may result from regulatory changes through their conventional monetary policy measures. They can raise or lower short-term interest rates. We may criticize the specific targets that the Fed adopts at given times, I now have, but in a well-functioning economy, they will be able to hit these targets. Moreover, the direct first-round impacts of regulatory change on employment growth are going to be modest anyway because they carry offsetting influences, so the Fed won't even have to do that much to counterbalance them. On the one hand, employment because of regulatory change is boosted because of the extra investments needed to bring producers into compliance, so power plants purchasing and installing scrubbers. On the other hand, a rise in the price level of energy because of the regulatory change may be transmitted to the overall economy by causing a slight rise in overall prices, and this may cause a reduction in spending. But it's clear that the first-round impacts, before the Federal Reserve decides to neutralize them, of regulatory change are indeterminate. And it's important to note that even regulations that have large measured compliance costs are no more likely to lead to job losses than those with smaller compliance costs. Compliance costs go on both sides of the job creation ledger. They represent both the scale of investments needed to bring firms into compliance, and they represent sort of the potential increase in prices that may result from them. When the economy is not functioning well, specifically a time like today when unemployment is high, even as the short-term policy interest rate controlled by the Fed sits at 0, this analysis changes. And the most important way it changes is that the Fed can no longer neutralize any effect of regulatory changes on employment growth. So instead of the Fed counterbalancing any change, these changes are actually likely to have multiplier effects that will ripple through the economy. The briefing paper that my written testimony is based on assesses these positive and negative first-round effects as well as the effect of the likely multipliers through the economy, and it comes to the finding that positive effects dominate. And I just want to point out quickly that its estimates are awfully conservative. Basically, they're conservative because the only real adjustment to the results I make is the assumption that the Fed can't or won't lean against whatever happens to employment because of the regulatory changes. But actually, there's plenty of reason to think that there will be very little scope for the overall price level to actually rise, given how much slack demand is in the economy today. I mean, basically the idea that when the capacity utilization rate of utilities is at the lowest rate on record, that regulatory changes will lead to large price spikes is a very hard thing to believe. And second, when you have economies with high rates of unemployment, chronic excess supply, they often see rapid disinflation, and that's what the U.S. economy has seen basically since what we now call the Great Recession started. And this disinflation actually leads to real interest rates rising even while the Federal Reserve is trying to keep them down, and this provides a brake on economic growth. So even if the price increase in the power generating sector is passed on to the overall general price level, this will actually arrest the upward pressure on real interest rates, and this would be as likely as not to be positive for overall demand. I don't include this latter consideration as an effect in my paper. So in short, I think my estimates of the likely job impacts of the air toxics rule by 2015 actually allow the widest scope possible for the negative impacts to run free, so I think they're very conservative. To conclude, I want to be clear. This is not a major jobs program. It's something that should be done because it will help Americans' health, but it will not reduce job growth.
I thank the gentleman. I yield myself 5 minutes. First of all, I want to compliment you. I've never seen an economist with so many hands. I tried to listen to your opening statement, and it was pretty amazing because it did balance so many but. So I will look forward to going through your conclusions once again after the hearing and see if I can't reconcile them. But let me go through a few things that I think are appropriate to your presence here today. First of all, you're here funded by the Blue-Green Alliance. Is that right?
No.
No.
I'm an employee of the Economic Policy Institute.
Do you work with the Blue-Green Alliance?
Yes, I have.
So would you say it's fair to say that a coalition of unions and environmentalists are essentially the people that you work with closely?
I have worked with closely, yes.
Would it surprise you to know that the International Brotherhood of Electric Workers, the AFL-CIO, has opposed the implementation of this standard at this time?
I did know that.
Okay. Well, without objection, I'd like to enter that letter into the record. Without objection, so ordered. I'm not an economist. I don't have a PhD, so I'm going to try and make everyone who looks at the record of this hearing a little bit simpler. And I appreciate the breadth of your knowledge and capability to balance that. So I'm not taking away from it, but I just think that most of us have to understand this a little differently. This standard does not create new, less expensive energy. Is that correct?
No, it does not do that.
It does, however, when fully implemented in 2015, reduce pollutants and thus has positive health benefits. Is that right?
That's my understanding.
Okay. And although there are some jobs created as a result of implementing this standard, those jobs are by definition either temporary, the 37,000 or so, or permanent. But the permanent ones are by definition greater ongoing cost of producing the same amount of electricity. Is that correct?
Yeah, I think that's correct.
Okay. So to put it in terms that my economist or economic professor at Kent State would have said, those are rocks in the knapsack. The benefit is you get cleaner air, and whatever you get from that is fine. But your ability to walk long distances are impeded by the rock in the knapsack. And this is an additional burden, an additional ongoing cost of producing the same amount of electricity. Would you say that's correct?
With one caveat. I mean,
Yes,
I think we're using more labor to produce the same amount of energy, but we're producing cleaner energy than we would have without that labor.
Right. And the benefit of cleaner energy would be the health care benefits, clearly, and we all agree to that. So on one hand, you've got a rock in the knapsack. You've got this cost, and the cost is at least 9,000 permanent greater jobs, estimated to be about $11 billion by what we might call the low side, the EPA's own estimate of best case. But we'll forget about the dollars. We just understand that you will have 9,000 more jobs to produce the same amount of electricity, and those jobs will add forever to the cost of producing that energy. So with that assumption, as we look at the speed with which they want to implement this, 3 years after only basically a 3-month look-see period, now extended by about a month, what if 100% of the mercury and 90% of the particulate worked out to be an answer which could be implemented with more available technology today? In other words, what if you could get 99% of the benefit, all of the mercury reduction and 90%, and I'm using that as a hypothetical figure, of the particulate reduction, and you could get that for a fraction of the cost, let's say $1 billion in additional cost, representing only hundreds of additional workers, hypothetically. If that were the case, as an economist, wouldn't you want that cost benefit looked at? Vast majority of the savings, perhaps in health benefits, 100%, because at some point as you reduce particulates, you have a drop-off in the health care benefit improvement. I grew up in Cleveland, a place that all the walls were black. You could see the air when I was a young man. So I'm very aware of the improvements made since the 60s. So my question to you is, wouldn't you as an economist want to have that information at your disposal to make a calculation of cost benefit to the economy on the long-term basis?
Yes. I mean, basically what you're saying is, could we achieve the same goals more productively, less labor needed? I would say in the long run, that sounds exactly right. I would say in the short run, we have a jobs crisis in the country. Everyone agrees with that. And actually, those compliance costs over the next 4 years represent job-creating investments that will be made that the corporate sector is showing no sign of making any other way. Instead, they're showing signs of sitting on massive amounts of savings without seeing any need to do those job-creating investments. And so that, to me, is why now is the time, assuming we've done all the due diligence about whether or not these rules should be done. If that is the case, and it strikes me it is the case, now is the time to do them, because it's what will help solve the jobs crisis we have over the next couple of years.
Well, I don't know if you were there earlier, but in the earlier testimony, what we had explained to us is there was 5 years of rulemaking and implementation after the passage of the Clean Air Act in 1990, and there has been as much as a full year for less controversial, less expensive proposed rules. Well, this one enjoyed roughly 3 months, now extended by a month. So the question would be, not as an economist, but from a standpoint of wanting to know, if going through nearly 1 million comments and evaluating those and evaluating the cost benefit that comes from those suggestions, if that would get you 90% for 10%, and of course allow additional technology to get the rest, wouldn't that be advisable for your finding the optimum benefit to the economy in the way of affordable energy, cleaner air, and of course job creation on both sides?
Yes, it would be useful to know if that was a possible scenario.
Well, we hope it is. With that, I recognize the ranking member.
I thank the Chairman. By the way, Mr. Chairman, you had asked earlier whether there were any coal-fired power plants that might meet this new standard. I think maybe you were out of the room when I entered into the record a list of coal-fired power plants right now that would, in fact, fully meet the standard, including 4 in my native Virginia, which contradicts the previous testimony. I now have been corrected. There are actually at least 6. The Chesterfield Power Station and the Virginia City plant, both run by Dominion Resources, would be fully compliant today.
Well, and hopefully the EPA will take and codify that list as exactly that, and I appreciate the gentleman.
I thank the Chairman, and I would also point out for the record that all of the at least 6 coal-fired power plants in the Commonwealth of Virginia that would be compliant are south of the Rappahannock. They're not in Northern Virginia.
You don't get to represent them?
I don't get to represent them, but our first witness does. You may recall his concern for poor communities bearing this brunt. Dr. Bivens, in following up on the Chairman's question about trying to follow testimony, you are now our 3rd witness, and we've had actually 3 different sets of data in terms of job numbers. Our first witness cited an industry-funded study that claimed that perhaps as many as 180,000 jobs could be lost. Our second witness from EPA said that the midpoint in their analysis was 9,000 jobs would be created, and you just indicated, if I heard you correctly, somewhere between 28,000 and as many as 150,000 net positive jobs created between now and 2015 if this rule were to go into effect. To what do you attribute the variance in these estimates? It's awfully hard as a member of Congress to sort of make the right decision policy-wise with such a wide array of job loss or creation estimates.
I can speak pretty clearly between the difference between my estimates and EPA. The industry-funded study is pretty opaque, so I can only guess at what is driving it. So the difference between mine and EPA's is EPA restricted itself to looking only at the likely job impact within the utility sector itself and with one supplying industry, steel, that's going to supply the scrubbers. And I think that they're missing a good chunk of the likely job impacts by not looking at the full range of jobs created by the investments spurred by the need to meet the regulatory change. And so that's what my study tries to do. It tries to look at both within the utility sector and outside it, looking at both the positive and negative. The industry studies that I've seen that have chalked up big losses regarding this rule, I think make two big common problems generally. Each one is a little different. First one is there seems to be a big discordance between their compliance costs and their price implications. So basically, they have compliance costs that look, relatively big, say 2 times as large as EPA, but then they have price spikes that are like 4 times as large. And given that the compliance cost, that dollar value, is the scale of investments that actually support jobs, those should actually move pretty much in tandem with the price increases. Because the only reason you have to raise prices in response to regulatory changes is if you have to hire new people in order to do the stuff that you have to do to comply with the new regulatory regime. And so I think they have consistently had price increases that are well out of line with the rest of their study actually looks at. And the other thing they don't do, I think, is properly account for the very different macroeconomic environment we're in right now. They basically assume it's kind of what would these investments do dropped into the U.S. economy at a normal point in time. We're not in a normal point in time. We've had 9% unemployment for 3 years, even while the Fed's short-term interest rates are stuck at 0. In the jargon, that's called a liquidity trap. It's a really important context for how the U.S. economy is operating right now.
My time is limited, so let me ask this question. Thank you. We've heard assertions made that this kind of regulation is a job killer, going to crush industry, going to actually pass on significant cost to consumers. And yet, when one looks at the data of the record of implementation of the Clean Air Act since 1970 and the Clean Air Act amendment since 1990, the data suggests the opposite. I wonder, as an economist, would you comment?
I agree with that characterization. I would urge people to look at a paper my institute did by Isaac Shapiro and John Irons, that they looked exactly at that, sort of forecast for what regulatory changes we're going to do to jobs, price increases, things like that. And consistently, in the end, the cost of the regulation was almost always much smaller than what was forecast ahead of time. So,
and the price of electricity?
I'm not sure if they looked at price of electricity. I mean, I would say I think the best estimate for what's going to happen to the price of electricity is the EPA's, and I see a lot of the other studies out there that look far out of line with that.
And just for the record, I'd repeat, in my native state, the Commonwealth of Virginia, since 1990, the aggregate cost or the net cost of electricity has actually gone down by 35.6%. With that, I yield back, Mr. Chairman.
I thank the gentleman, but if I can ask the gentleman a question about your state. In Virginia, for those to go down, I'm presuming that since it's a rate base on their cost, that in fact that's a matter of efficiency. In order to reduce cost over that same period of time, they produced more electricity at lower cost, where they're getting a return on their capital, regulated return on their capital. So in this case, where the EPA, by its own estimates, has a cost of implementation, those costs would be passed on. So there'd be at least a temporary spike in what otherwise is a cost-benefit reduction that they've been achieving for that period of time.
I think the Chairman makes a fair point that obviously that could happen. I would only point out, though, that contrary to our first witness's testimony, the reason for price spikes in especially rural parts of Virginia has to do with the re-regulation of the industry, a bill that was written by the industry in the General Assembly of Virginia. It had nothing to do with Federal regulation.
I appreciate that explanation, and I will tell you that as somebody who has seen our state go through deregulation, dramatic reduction in cost, and then blackouts, and we have partial re-regulation, although not complete, it is one of the challenges. Do we give the regulated utilities, and I realize this is what I'm going to ask one last question to the witness, but regulated utilities, when they're given a cost-plus situation, they love cost. They often do not complain about cost drivers because they can pass it on, which essentially grows the benefit to their stockholders. Well, at the same time, they will say they want a free market system, but not unless it gives them greater profit margins. So I think the gentleman has a good point in your state, as I do in mine.
I agree with the Chairman.
At this point, I should adjourn. But I want to thank the witness. Dr. Bivens, you were very helpful. Your entire statement will be there. Additionally, because you had not as many witnesses, but you had some questions related to some economic hypotheticals that may be beyond what even in your thorough comments you provided. Any additional for the next, let's say, 7 days, and if you need longer, let us know. We'll keep the record open so that anything you believe are missing analysis, either on the upside or the downside, we'd appreciate having. Additionally, if you could do me a personal favor, or the committee a personal favor, to the extent that you could try to deliver us a timeline cost of money, in other words, the cost of a delay, as they just had, of 30 days in the implementation, and the benefit that is potentially there from slight adjustments in the final standard, how you think the parameters of best case of a slight change and worst case of a slight change, because delay has a cost to cleaner air. Well, getting it right may have a benefit to lower cost and ultimately greater affordability. I didn't see that in your earlier stuff. It's kind of esoteric. But I think for all of us who want to weigh, not just on this bill, but in future hearings, do we delay to get it right? What is the cost of delay? Something that, since we're talking about 1990 till today, I think we have to put in that perspective. And I'd yield to the ranking member.
Mr. Chairman, I support your request. I think in the endeavor to try to better understand the economics of this, that would be a very helpful contribution. I wonder if the Chairman would also entertain asking Dr. Bivens perhaps to provide a little more analysis on his answer to the question about the job number variation we've heard in this hearing, because we've heard 3 different sets of numbers, and I certainly would welcome Dr. Bivens taking some time to help us better understand the different methodologies that led to those different sets of numbers.
Absolutely.
I thank you, Chair.
To the extent that you could, and that was what the ranking member said it maybe more artfully than I did, because we do see where one side is looking at the cost of jobs, higher utility cost and so on, and another side, self-servingly and rightfully so, is looking at the jobs created. And obviously we want to look at the balance, particularly in regulated utility states. I think that the doctor's comments were exactly right on. In a free market regulatory state, much of this could be a compression of profits of the utilities. Well, in those states that are cost plus or regulated, it's going to be passed on. And I think that's one of the things that the ranking member made such a good point of. And with an affirmative yes, we stand adjourned.